Thanks so much, Steve, for that very generous introduction. As Steve said, the topic of my talk today is Catholic social thought and criminal justice reform. I thought I'd spend 20 to 30 minutes talking about some of these issues and then open it up for discussion because I really do want it to be a discussion. Three disclaimers first at the outset. One, I'm not a theologian. My training is as a lawyer. Notwithstanding, I love to engage in personal reading on the subject. I have an undergraduate education in the Catholic space, and I've followed lots of people's work in this room who know far more on the subject than I do. I am not a theologian, so the topic of today's discussion might more accurately be described as the criminal justice system, one Catholic's perspective. I am a Catholic. I strive imperfectly to follow the Gospels, but I am not a theologian, so I appreciate comment from some of the theologians in the room. Second, I'm not a moral philosopher. Many of you probably know that there are two kind of dominant strains of Catholic social thought. One which relies on the Gospels as a source of revelation, and one which relies on natural law theory, particularly the work of St. Thomas Aquinas and Aristotle. I also am not a moral philosopher and a natural law theorist. There are people in that field in this room, and I will count on their comments as well, where I make mistakes in that regard. What I'm going to rely on is the Gospels and the pastoral letters and encyclicals that interpret the Gospels, and really talk today about what they can tell us about criminal justice reform. And I hope that this talk will have meaning to people of all faiths in the room. It is my particular faith tradition, but I think some of the concepts that I'll be talking about will really resonate with people from lots of different faith traditions or perhaps no faith traditions. And my third disclaimer, I want to put right up front that punishment and incarceration of criminals is not only consistent with Catholic social teaching, but it's also compelled by it. As the tragedy yesterday in Sutherland Springs, Texas teaches us, there is evil in the world, and the role of the state is to protect the rest of us from that evil as best it can so that individuals and families can flourish. So what I'm going to be talking about today, particularly about mass incarceration, really relates to incarceration for nonviolent offenses and property offenses. Violent offenses, offenses that involve exploitation and drastic harm to the individuals. Obviously, we need to punish those people. We need to punish them severely, not only to make a statement about our values, but also to protect the communities. So with those three disclaimers, let me just start by talking about three values that animate me as I think about criminal justice reform. And as Steve mentioned, I write in this area and I've written about some of the proposals that I'm going to talk about. But before I get to the proposals, I want to tell you what animates me about my faith and what I think the Gospels compel me to think about as a Catholic who's a criminal law scholar. So I want to focus on three teachings or three tenets of Catholic social thought, love, mercy, and redemption, and say a few words about each before I then move on to my proposals. First, love, or what the Greeks called agape. In the Old Testament, justice was the social principle that would promote solidarity among the people. In the New Testament, it was love. Love was considered to come before justice. That is, love is primary to justice. Love was the transcendent value that would lead to justice. And in the Gospel of Luke, Luke tells the story about Jesus and Jesus teaching everybody the parable of the Good Samaritan. I suspect most people in this room are familiar with that section of Luke's Gospel. An expert in the law stood up to test Jesus and said, "Teacher, what must I do to inherit eternal life?" "What is written in the law?" Jesus replied. He answered, "Love the Lord your God with all your heart and with all your soul and with all your strength and with all your mind, and love your neighbor as yourself." And Jesus said, You have answered correctly. And then he proceeded to tell the parable of the Good Samaritan. Now, many people on first hearing the parable of the Good Samaritan think that the parable of the Good Samaritan is just about who is your neighbor. But the parable about the Good Samaritan is also about how we define neighbor, not only what a neighbor's obligation is to their neighbor, but who is your neighbor. And at the time, of course, Samaritans were the lowest rung of the social ladder. They were considered outcasts. And Jesus was making the point that Samaritans, isn't it interesting that the Samaritan is the one who decided to help the traveler on the roadside, but Samaritans are our neighbors. Everybody is our neighbor. And we know this from Pope John Paul II's Santissimo Annus encyclical, where he says, every person is created in the image and likeness of God and deserves our respect. I think that's worth repeating. Every person is created in the image and likeness of God and deserves our respect. So when we talk about criminals, when we talk about people who have been convicted of crimes, who are in jail, we have to remember that prisoners are our neighbors, and the gospel compels us to love prisoners. We also know that from the parable of the sheep and the goats, where Jesus tells us what will happen when God comes to judge, and God will separate the sheep and the goats. And of course the question is posed, how will we know the sheep from the goats? And Jesus says, for I was hungry and you gave me nothing to eat. I was thirsty and you gave me nothing to drink. I was a stranger and you did not invite me in. I needed clothes and you did not clothe me. And wait for it, here's the important part. I was sick and in prison and you did not look after me. I was sick and in prison and you did not look after me. And of course those in attendance said, when did we ever see you sick and in prison and not look after you? When did we ever see you without clothes and not look after you? And Jesus said, whenever you did not do this for the least of your brothers, you didn't do it for me. Right? So what Jesus is essentially saying is, think of me as a prisoner. You need to love prisoners just as you love me and love yourself. And when we think of prisoners in our society, prisoners are the people who have certainly the least political clout, the least social standing, the least power in our democratic system. And they perhaps are also the most invisible. And the French philosopher Simone Weil once said that love sees what is invisible. Love sees what is invisible. So I would like you to think of, perhaps, if prisoners are invisible in our society, and the second commandment compels us to love our neighbor and love those who are invisible, how important it is that we love prisoners and we extend that love even to the invisible in society. So I guess the Catholic ethos of love, in my mind, commands us to, notwithstanding hatred, notwithstanding political rhetoric, notwithstanding perhaps most of all fear, the Bible teaches us that we need to love prisoners. The second Catholic ethos I want to talk about is the ethos of mercy. The Catechism of the Catholic Church teaches us that human misery, including poverty, sickness, and imprisonment, are, and here I'm quoting, obvious signs of the inherited condition of frailty and need for salvation in which man finds himself as a consequence of original sin. Showing compassion to widows, the poor, the frail, and people imprisoned are works of justice pleasing to God. So my faith teaches me that mercy towards those who are imprisoned is commanded by my faith and commanded by God. And Jeffrey Murphy, one of Steve and my colleagues who teaches in our space, teaches criminal law, but is also a theologian, I think he said it best about the intersection between criminal punishment and mercy. Professor Murphy said, it is important to see that the requirement of mercy is best understood not as a requirement never to punish, but rather as a requirement to develop a character that is not hardened and rigidly formalistic, a requirement that leaves room for considering relevant features of a criminal, remorse, repentance, or apology, for example, that might legitimately incline one to favor a reduced sentence for that criminal. On the subject of mercy, I've also been inspired by the work of NYU Professor Bryan Stevenson, who, as many of you know, is a death penalty litigator who founded the Equal Justice Initiative in Alabama. If you haven't read the book, Just Mercy, I commend it to you. It's a very powerful recount of the death penalty in America and his litigation on behalf of those who have been accused. Stevenson wrote about working in a broken criminal justice system, and I think his words are really important about mercy. Although he didn't bring it from a Catholic perspective, he was a Christian, and his prose sometimes reads as if he's preaching from a Christian perspective on the pulpit. This is what Stevenson had to say about his work. For the first time, I realized that my life was just full of brokenness. I worked in a broken system of justice. My clients were broken by mental illness, poverty, and racism. I guess I'd always known, but never fully considered, that being broken is what makes us human. But our brokenness is also the source of our common humanity, the basis for our shared search for comfort, meaning, and healing. Our shared vulnerability and imperfection nurtures and sustains our capacity for compassion. The power of just mercy is that it belongs to the undeserving. It's when mercy is least expected that it's most potent, strong enough to break the cycle of victimization and victimhood, retribution and suffering. It has the power to heal the psychic harm and injuries that lead to aggression and violence, abuse of power, and mass incarceration. So I think that Bryan Stevenson had it just right. Mercy is one response by society that can actually serve as an antidote to evil and an antidote to hatred. So that's why the Gospels compel us to have mercy on sinners. Pope Francis, 2 years ago, when he was visiting a prison right here in Philadelphia, echoed those same words. First pope in a long time to visit a prison. And he visited a prison on his trip to America, right here in your city, and he said, "It is painful when we see prison systems which are not concerned to care for wounds, to soothe pain, to offer new possibilities," he said. "It is painful when we see people who think that only others need to be cleansed, purified, and do not recognize that their weariness, pain, and wounds are also the weariness, pains, and wounds of society." I think those words are very, very powerful. When we're bestowing mercy on somebody else, we are recognizing that part of their brokenness is our brokenness as well, isn't it? The third concept I want to talk about is redemption. My faith teaches that we were all created in God's image, as I already discussed, but yet we are also all sinners who occasionally turn away from God. Each of us is better than the worst thing that we have ever done. I know that I am better, or I would hope I am better than the worst thing I have ever done. But my faith also teaches that each of us has the capacity for reconciliation with God. My church teaches that God gave his only Son so that all humans, be they believers or unbelievers, could be redeemed by Christ's sacrifice. The Catholic Church does not agree with the Calvinistic doctrine that Jesus died for the salvation of a predestined few, or that certain people are destined to be eternally damned. My church tradition preaches in the unity with the Holy Scripture that he, Jesus, became the source of eternal salvation for all. And Pope Francis, my Jesuit hero, go BC, right, Pat? We love Pope Francis for lots of reasons, but as a Jesuit pope, he really inspires Jesuit colleges and universities here in America, particularly Boston College. He said in a 2013 general audience, he reiterated this point about all having the capacity for redemption when he said, "The Lord has redeemed us all of us, with the blood of Christ." All of us, not just Catholics, everyone. And that point received a lot of press attention at the time. So, the Catechism of the Catholic Church calls on its members to clasp sinners to their bosom, just as Christ did in inviting sinners to his table, which we all remember was a gesture that astonished the rich and the powerful at the time, having sinners at the table, right? That's what we do with sinners. We show them mercy and we love them. In November 2000, the Conference of Catholic Bishops wrote a pastoral letter on punishment in America, and that pastoral letter is called Responsibility, Rehabilitation, and Restoration. I urge you to read it if you have never done so. I think it's a very, very important document. And the Catholic bishops said this in 2000 about punishment. We are all sinners, and our response to sin and failure should not be abandonment and despair, but rather justice, contrition, reparation, and return or reintegration of all into community. So with those three values, love, mercy, and capacity for redemption in the back of our minds, I now want to turn to what I would say are 5 implications for criminal justice reform. And there could be 55 implications for criminal justice reform. I could be here all night, but I only want to keep you for an hour. So these are the 5 that are important to me. These are the 5 that I've been thinking and writing about. These are the 5 that, as a Catholic who strives imperfectly to live a life according to the Gospels, these are the 5 that I think are urgent for us to think about, particularly in America. The first is that we need to abolish the death penalty. Although the death penalty is not wholly outside the Catholic tradition, as many in this room know, and it's even mentioned approvingly in the New Testament, the modern Catholic Church has recognized that it has clear evils associated with it that under current conditions vastly outweigh its benefits. It has a disparate impact on people of color, the poor, and the marginalized. It's not free from irremediable error, and it stands in direct conflict with the Church's teachings on the sacredness of human life. So in Evangelium Vitae in March of 1995, Pope John Paul II, in his papal encyclical, told us that capital punishment is wrong. Given the development of the modern penal system, the need to execute a convicted felon is very rare and practically non-existent. So where do we stand on the death penalty in America today? Well, we still have the death penalty in 30 states, and we still have the death penalty for certain federal crimes. Although the actual execution of federal prisoners sentenced to the death penalty has been fairly rare since 2000. But the trend is towards the abolition of the death penalty at the state level. Since 2004, 7 states have eliminated the death penalty. 2 of them have done it by judicial decision, New York and Connecticut, and 5 of them have done it by legislation, New Jersey, New Mexico, Illinois, Maryland, and Nebraska. Now a total of 20 states and districts have abandoned the death penalty, and I think the movement is in that direction. And there's some reason for optimism, even on the federal level. In the 2002 case of Atkins versus Virginia, the Supreme Court ruled that the 8th Amendment's prohibition of cruel and unusual punishment forbids the execution of the severely mentally disabled. And they said this in doing so: the determination whether a punishment is cruel and unusual turns on its consistency with the evolving standards of decency that mark the progress of a maturing society. In concluding that the execution of the severely mentally disabled was unconstitutional, the court invoked a brief filed by the European Union, which cataloged the overwhelming repudiation of the practice by the rest of the world. That is, the Supreme Court was willing to look to the rest of the world in deciding whether executing the mentally ill was cruel and unusual. I think we will get to a point, perhaps not with this Supreme Court, but with a future Supreme Court, where they're willing to say that the death penalty violates the cruel and unusual punishment. Because if you look to the rest of the world, 140 nations have abolished it by either law or practice. And just last year, in 2016, only 23 countries carried out an execution of a convicted criminal. Only 23 countries. And that's 23 countries who are either UN nations or have UN observer status. So the death penalty has been recognized by most modern nations as cruel and unusual, and ineffective. I think the United States of America will come to that point eventually too. But I think our battle right now is really with the states, because that's where we've seen movement. The second conclusion that the ethos of love, mercy, and opportunity for redemption lead me to is that we need to eliminate mandatory minimum sentences for most crimes. And as Steve noted, I've written about that in my scholarship. I was a drug prosecutor in the late 80s when the war on drugs was a thing in America, and I put people in jail for a long time. And as I look back on my life, I regret my participation in that war, and I think I sent them to jail for too long a period of time. At that time, selling over 200 grams of cocaine in Massachusetts subjected you to a 15-year minimum mandatory sentence. Think about that, 15 years for selling over 200 grams of cocaine. And for those of you who are familiar with the joint venture doctrine, it's not just the person who does the sale who goes to jail for 15 years. It's the person who drives the car. It's the person who acts as a lookout. It's any accomplice who counts the money. I sent lots of so-called mules or accomplices to jail for 15 years for just being a participant in the sale of 200 grams of cocaine. That just wasn't right. It wasn't right then. It's not right now. The literature and the data are overwhelming. Our nation's unparalleled incarceration rates are harming families, and they're tearing apart communities. Despite having only 5% of the world's population, the United States has 20% of the world's prisoners. And the majority of those prisoners, almost 60%, are African American and Hispanic. That's just not acceptable. It's not acceptable as a moral matter. It's not acceptable as a fiscal matter. Long prison terms are contrary. They are contrary to fiscal sense. They're contrary to the moral weight of the crime. You know, being a driver of somebody who sells 200 grams of cocaine does not warrant 15 years in prison. And they're depleting state and federal budgets. The United States spends over $80 billion a year on incarceration, over $80 billion a year on incarceration. And in many states, education, health and human services, and public transportation budgets remain stagnant or decline while more and more prisons are built. The U.S. has the highest incarceration rate in the world, 676 inmates per 100,000 people, compared to Norway's 80 inmates per 100,000 people. Yet if you compare our recidivism rates are between 40 to 60% within 3 years, depending on how you calculate recidivism, which varies from jurisdiction to jurisdiction. But Norway's recidivism rate is 25% within 3 years. So clearly, the trend towards longer and longer prison terms is not causing people to commit fewer crimes. In fact, the literature suggests the opposite. Not only are long prison terms expensive, but there's little correlation between length of prison sentence and public safety. One reason long prison sentences can lead to increased recidivism is that defendants who are sentenced to long periods of incarceration tend to be classified at a higher security level in prison. That means they're going to be in a medium or maximum security prison when they should be in a minimum security prison. And spending time in maximum rather than medium or minimum security facilities inhibits rather than promotes participation in programs such as Alcoholics Anonymous, Narcotics Anonymous, job training, because many of those programs are not available in maximum security prisons. I'm quoting a Pew Charitable Trust study here. An analysis of data from 3 states, Florida, Maryland, and Michigan, found little or no evidence that longer prison terms for many nonviolent offenders produced either incapacitation or deterrence effects. That is, the extra time behind bars neither prevented crimes during the period of incarceration nor kept offenders from committing crimes once released from prison. Now, a top priority in sentencing should always be to protect the public from dangerous people. But fully half of our prisoners in America are in jail for drug or nonviolent offenses. So my perspective and what I'm advocating for is that we eliminate mandatory minimum sentences for all but first-degree murder, third or subsequent offense OUI, or the most extreme cases of violent recidivism. There are a couple ways we can do that. One is what's known as the safety valve. Personally, I think that the safety valve is a judicial compromise. It's a half effort. But a judicial safety valve gives a judge the power, if certain preconditions are met, to deviate from a minimum mandatory sentence. There is a federal safety valve. It was enacted in 1994 and amended in 2002, but it only applies to 5 federal offenses, and they're all drug offenses. Other offenses that carry minimum mandatory sentences, even other drug offenses that carry minimum mandatory sentences, are not covered by that safety valve. And there have been efforts in Congress since 2013 to amend that safety valve to have it apply to more offenses. Many states have done that. Oklahoma and Connecticut are 2 examples. I say that's a political half measure. I'd rather have that than nothing. But what I would really like to have is a repeal of most mandatory minimum sentences. And some states have begun to take that approach as well. Over the last few years, South Carolina, Rhode Island, Michigan, and New York have eliminated at least some drug mandatory minimums completely. And those states present a model for other state reform. Some states have done the same thing by raising weight thresholds, increasing school zone distances, or just lowering the minimum mandatories. Again, I think those are political half measures, but I'd rather have them than nothing. The third reform I want to talk about that I think is consistent with the Catholic ethos I discussed at the beginning is stepping prisoners down to community corrections so that they can maintain their family ties. While incarceration is sometimes necessary, it is usually harmful to individuals, to relationships, and to the families of the incarcerated. We have to recognize that 95% of prisoners are going to return to their communities in this country, 95%. But people now do not come out of prison better off than when they went in. Individuals who have been swept up in mass incarceration are coming back to their communities with significant, if not insurmountable, barriers. No home, fractured family relationships, massive unpaid child support obligations, no education, no work experience, no job, and a criminal conviction that will prevent them from getting many jobs, and the same substance abuse and mental health issues that may have contributed to their incarceration in the first instance. We need to promote healing in prisons and to make it easier for people to get back on their feet when they get out of prison. And one way to do that is to substantially improve reentry programs. We should be looking for more successful outcomes rather than a 3-year recidivism rate that hovers between 40 and 60%. This is where reentry comes in. We need to shift correction agency goals from security, simply housing and maintaining offenders, to offender behavior modification. According to a 2014 RAND study, the odds of recidivating for people who participated in educational programs while in prison were 43% lower than the odds of recidivating among the comparison group of prisoners who did not. And one important starting place here is regional reentry centers, which are often called community correction centers at the state level. The feds call them regional reentry centers. Many states call them community correction facilities. Think of them as halfway houses. That's what they used to be called 20 or 30 years ago. Halfway houses, halfway between imprisonment and full freedom. It's a form of minimum security facility that's designed to facilitate the transition to independence. Certain prisoners in a community correction facility are eligible for work, and they can leave the community correction facility during daylight hours to work. Reentry used to be about simply getting inmates Social Security cards or other forms of identification before they left, and a bus ticket. That's what people thought of as reentry. Now the goal of reentry planning is far broader. It supports not only recidivism reduction strategies, but also considers a person's employment, housing, interpersonal relations, and other factors affecting the person's well-being. My point is that state and federal correctional departments must wholeheartedly commit to having every prisoner spend the last 6 to 12 months of their sentence in a regional reentry center. The goal has to be 100% participation. And the only way we can get there is step down from classification. Because usually reentry centers or community correction centers at the state level, you're only eligible if you're a minimum security inmate. It depends on Department of Correction regulations in each state, but you generally have to be a medium or minimum security inmate to even be eligible for participation in a reentry center. So if you've committed a bank robbery and you were an accomplice to a bank robbery and you're classified as a maximum security inmate because somebody used a gun in that bank robbery, you're not going to likely get to see a regional reentry center. You're going to be released to the street from a maximum security prison. And in a maximum security prison, you have access to far fewer programs than you do in a minimum security prison. So my point is we need to have a presumption of step down from maximum to medium to minimum security and then release to a community correction center 6 to 12 months before your final release. This is nothing new. The reentry program, the reentry vision has been around as a model for 10 years. The problem is it's very fragmented. The feds do it one way, states and counties do it another way. They don't talk to each other, and not every prisoner is eligible. It's a highly, highly fragmented response to what is a unified problem that every correctional facility in America has. When and where do we send somebody to a reentry facility before their release? You know, the federal government has the means of cooperating with the states when they want to. The federal government contracts with houses of correction and jails all across America to house immigration detainees. They know how to do it. They know how to pay the states for the beds that they're taking up with immigration detainers. You can have models where a community correction center is run by a county facility and the beds are paid for either by the state prison or by the federal prison, depending upon who's using how many beds. That is not a model that's beyond our imagination. In fact, anybody here from California? Okay, you familiar with what's going on with California right now with reentry a little bit? So as a result of a Ninth Circuit decision saying that California was housing too many prisoners and that the facilities and the programs and the mental health treatment in particular were barbaric because there wasn't enough staff, the Ninth Circuit put a cap on the state prisons in California, and the U.S. Supreme Court affirmed that cap. So California had to do something with its state prisoners. Well, of course, necessity is the mother of invention. What did California do? California adopted the California Public Safety Realignment Act of 2011. And what they did was they sent their state prisoners to houses of correction, and they paid the counties for housing the state prisoners because that got around the cap. Well, guess what California discovered? California discovered that county houses of correction were better at reentry than maximum security prisons because they had established halfway houses. So the results since 2011 in California are remarkable. And it's not because California wanted to do it, it's because they had to do it. But the studies have shown that counties that put attention and resources into prisoner reentry services and programming have seen better recidivism outcomes than counties that pour more money into additional law enforcement, sheriffs, or jail beds in maximum security prisons. Okay, fourth, where am I led with my values of love, mercy, and opportunity for redemption? I think we have to promote diversion where possible through problem-solving courts. Now, the problem-solving court movement is nothing new in America either. It's been around for over 20 years. Actually, it's the grandfather of the problem-solving court movement was really the juvenile justice system, which has been around for over 50 years. Pretrial diversion is the practice of channeling certain offenders out of the criminal process. It's an early intervention strategy that promotes personal accountability and responsibility. Many states now have problem-solving courts for drugs, domestic violence, and veterans, in addition to the juvenile justice system. And those problem-solving courts usually work as follows. The offender, the alleged offender, is taken before probation, and probation determines whether that offender qualifies for diversion. Usually there are a list of crimes that qualify and a list of crimes that don't, and it might depend on the offender's criminal history. If the offender is offered diversion, the defendant chooses to accept that offer in exchange for a stay of the criminal proceedings or a continuance without a finding upon successful completion of diversion. And if the offender diverts, the judge can dismiss the criminal charges at the end of the diversion period, and the defendant is left with no record. Now, what happens to the offender during the period of this diversion? Well, it's a therapeutic justice model. That's why it's called a problem-solving courts. A problem-solving courts works with community service providers to address a defendant's behavioral, psychological, and substance abuse problems, and it takes a collaborative and multidisciplinary approach to address whatever underlying issues brought that offender before the court. And if they can be addressed successfully, the crime is dismissed at the end of the diversionary period. It's called the therapeutic jurisprudential model because its focus is on rehabilitation. It is perceived as beneficial to public safety and community order to keep the defendant out of the criminal justice cycle by improving his or her psychological and physical well-being. And I think rehabilitation is consistent with the opportunity for redemption that God gave to all of us through the sacrifice of his Son. So my recommendation here, again, problem-solving courts are nothing new. My recommendation is we need to extend problem-solving courts far further than we have already done so into the mental health arena. Right now, there are over 3,000 so-called drug courts in America, but there are only 400 mental health courts. And mental health is an issue that causes lots of people to end up in the criminal justice system. Indeed, based on my experience, I'd say it's a combination of poverty, substance abuse, and mental health that leads to lots of criminogenic behavior. So we need to have more mental health problem-solving courts. And that's because the definition of insanity in our country, for those of you who are 1Ls taking criminal law, you know that the definition of legal insanity is so high that it's very rare that somebody can meet the test for legal insanity because they do know right from wrong, but yet they have serious mental health issues that lead them into the criminal justice system. So defendants should be invited to participate in the mental health court following a specialized screening and assessment. And for those who agree to participate, a team of court staff and mental health professionals should work together to develop treatment plans and supervise participants in the community. Why are there so few mental health courts relatively compared to drug courts in America? I think that lawyers are a little bit leery of the multidisciplinary approach and collaborative approach with mental health professionals that would be required to figure out what a person's needs are and what their likelihood of reoffense is. We're not well trained in that regard, are we? And we have an adversarial system of justice rather than a collaborative system of justice in America, don't we? But I think we really need to extend as far as much as possible. In every major urban area in America, we need to have mental health courts. A lot of work still needs to be done on the issue of the intersection of criminal justice and mental health in America. A survey of defendants who worked with one mental health problem-solving court in Florida reported higher scores on a dignity scale and lower scores on a perceived coercion scale than any group of criminal defendants that were ever studied. Okay, and finally, my last recommendation, or the last reform movement that is animated by my faith, I should say. I have plenty of recommendations I won't bore you with, but the one that's really animated by my faith is presumptive parole. Most state statutes vest substantial discretion in parole boards to allow release at some percentage of the offender's minimum term if there's a reasonable probability that such inmate will live and remain at liberty without violating the law. But risk of reoffense is a very difficult thing to predict, and many parole boards are highly risk averse. Parole rates will vary considerably from jurisdiction to jurisdiction depending on an offender's offense level, their prior criminal history, and which party has the burden of proof. If the defendant has the burden of showing that he's not at a risk of a reoffense and the parole board is risk averse, the likelihood of him getting parole is low. So the burden of proof often affects parole determinations. More states should commit themselves to presumptive parole for nonviolent offenses, is my perspective. Offenders who have participated in recommending program in prison should be presumed eligible for parole on their first eligibility date, unless the parole board finds by a preponderance of the evidence that the offender prevents a risk of reoffense. And the burden should be on the state, not on the defendant. I'm not saying everybody should be entitled to presumptive parole, but I'm saying for designated offenses, particularly nonviolent offenses, there should be a presumption of parolability on the first parole date. And 7 states, including New York, South Dakota, West Virginia, New York, New Jersey, Mississippi, Florida, and Colorado, have moved to this so-called system of presumptive parole for nonviolent and other designated low-level offenses. And several states currently have presumptive parole under consideration. We're battling that fight right now in Massachusetts, as is Kentucky. Of course, presumptive parole is going to require prison-based programs that are responsive to inmates' needs. Violence prevention, anger management, Alcoholics Anonymous, Narcotics Anonymous, GED equivalence programs, and vocational trainings are all ways in which we can reduce the likelihood of reoffense. But there are lots of barriers to participation in these programs. One barrier, as I've already mentioned, is classification. You know, the higher somebody's classified in the system, the fewer programs are available to them. Another barrier is resources. Quite frankly, we as a society have to commit more money to social workers and less money to maximum security correctional officers and prison beds. We just have to make that value choice in our society. In addition to being about resources, it's also about overclassification, as I've mentioned. The supervision level of a facility can place sharp limits on the variety of delivery of programs. So we need to, as I previously mentioned, in order to support both parole and reentry centers, we need to have a step-down classification system from maximum to minimum security. And we have to ensure that every prisoner has the opportunity to step down. I'm not saying anything new here. The U.S. Conference of Catholic Bishops were prescient on this subject in 1973. 1973. Think about the pendulum in criminal justice in America since 1973, right? In 1973, in a pastoral letter, Rebuilding Human Lives, the U.S. Conference of Catholic Bishops set forth 22 specific recommendations about prison life in America, and one of them was parole is to be assumed unless there are good reason to withhold it from inmates. So the Catholic bishops have been in support of presumptive parole since 1973. So let me just sum up. In conclusion, criminal punishment is essential to maintaining order and protecting public safety, but we also need to recognize that it leads to lots of societal ills, and those ills are corrosive to community and to individual flourishment. Those ills include loss of family ties, stark and demeaning prison conditions, an impetus in prison for prison gangs, and perhaps most important, an exacerbation of racial and class tensions in our society. In its 2000 letter, Responsibility, Rehabilitation, and Restoration, the Conference of Catholic Bishops said, "We are guided by the paradoxical Catholic teaching on crime and punishment. We will not tolerate the crime and violence that threatens the lives and dignities of our sisters and brothers, and we will not give up on those who have lost their way. We seek both justice and mercy." So in my view, our society has become alienated from the ideals of love, mercy, and opportunity for redemption. I believe that refocusing on these Catholic ethos can be an important foundation for reforms in our criminal justice system. And I'd invite all of you who are here today who share my faith tradition or don't share my faith tradition and still believe in the ethos of love, mercy, and opportunity for redemption to find out what's going on in your jurisdiction on the issues of criminal justice reform, to communicate with your legislators, and to keep those values in mind when you enter the ballot booth. So thank you very much. Oh, I didn't do very well on time, Barbara. I'm sorry, or Steve, whoever's keeping time. You're very welcome. Let's have a conversation. Questions? Yes?
I'm actually trying to introduce my friend Liz here. She has an appeal to make to all of you. It's in accord with everything you've been saying.
Oh.
My name is Joe Betts. I'm a retired philosophy teacher here. In teaching here for 21 years, I went out to Graterford Prison. I taught 12 different courses there. In 2 of the courses was an inmate named George Trudell. George Trudell was a boyhood friend of Liz Geyer's husband. Liz Geyer's husband died. When he died, George Trudell from prison sent letters to Liz describing good childhood connections. Liz has become a very, very effective advocate to try to get people to support George Trudell's release after 21 years. He spent 29 years for a felony murder charge. He was like the driver of the vehicle that had the drugs in it. He didn't murder anyone, his companion did. He was guilty of the felony, but not in the narrow sense of the murder. But at any rate, I'd like you to hear Liz. I found her very, very articulate. Among the marks of her articulateness is when she goes to see Lieutenant Governor Mike Stack, who is chair of the Parole Commission in Pennsylvania, he calls her by name. He says, "Hello, Liz," and she says, "Hello, Mike." So please hear Liz out for a couple of minutes.
Liz, take the podium.
Hello, everybody. My name is Elizabeth Geyer, and like Dr. Betts said, George is my boyfriend, and I've become a huge advocate for prison reform through, I don't know if anybody's familiar with HB 135 and SB 293 bills, the Senate and House bills for Pennsylvania. They're gaining a lot of attention. What I'm looking to do is to, in Pennsylvania, there is life without parole. There is no eligibility at all for parole for people like George. He's a Villanova alumni. He received his bachelor's here in 2012. He's received the support of Dr. Betts, Dr. James Wetzel is behind him, Dr. Ronald Paul Hill from Villanova, Dr. Brian O'Neill from Westchester University. So a lot of people have supported him for many years. He's a gentleman that has completely, in my opinion, redeemed himself 100% from the troubled boy that he was as a teenager, committing not the murder, but being in a situation where a murder had happened, someone was killed, and that gentleman that killed the person took a plea deal of third-degree murder. He admitted the murder, and he was released in 7 years, the murderer in George's case. George felt at the time, being a 20-year-old street kid, felt that, well, I didn't kill anybody, so, I shouldn't, be in trouble. So he pled not guilty. Had no representation at the time. His family was he was a very poor child, poverty, grew up in a bad neighborhood in Frankfurt section of Philadelphia, and went with a court-appointed attorney and received life without parole. That's the mandatory sentence for second-degree felony murder. Although he did not murder anyone. And to this day, he sits in Graterford Prison. He'll be starting his 30th year in prison December 8th of this year. My plea is to anybody that is passionate about, especially the bill, HB 135, which is eligibility for parole at least. Not saying that all lifers should be released. That's not what we're saying. Deserving lifers that have proved over many decades how they have reformed and how they have changed as a person. And It's from State Rep Jason Dawkins has introduced that bill, HB 135, and it's getting very big. I don't know if you see it on TV a lot. There was a big rally last week in Harrisburg, the Rally for Redemption, for deserving lifers in Pennsylvania, which Lieutenant Governor Mike Stack was with us. He's a huge supporter of it. He runs Pathway to Pardons. That's you can go practically every week. You could go to a Pathway to Pardons meeting all over the city of Philadelphia. If you go onto his site, it's Pathway to Pardons. Lieutenant Governor Michael Stack, he speaks at them. He introduces himself to everyone, and it's mainly the same people every week that feel they have a deserving lifer, brother, sister, husband, wife, that has proved their redemption, that they should be home. The second bill that is coming up is the SB 293, who was introduced by Senator Dalen Leach, if you're familiar with him. That is a Senate bill that he is passionate about with what my boyfriend is dealing with, the second-degree felony murder law. It is so stringent and so strict, and it's actually, in my opinion, ridiculous that a person involved in a crime that didn't do the murder does the same exact amount of time, does a life without parole, and didn't commit a murder. Perfect example with my boyfriend, like I said, the murderer got released 22 years ago. My boyfriend is getting his life without parole because he pled not guilty to something he didn't do. But because a jury found him guilty as an accomplice to second-degree felony murder, he is sentenced to die in prison. So I guess I'm just trying to make my case with you to look into, especially HB 135, just to give at least eligibility for parole to deserving lifers that have proved, like on paper, and with the staff at Graterford or the staff at any state prison in Pennsylvania that would speak on their behalf. We've made huge leeway with the governor, Tom Wolf, and it's finally starting to help, to work for me. We just received a letter last week that George has been granted a merit interview with the prison scheduled for August of 2018, which was granted by the Board of Pardons. Because of I'm a very pushy person. I'm very nervous. I've never spoken in front of this many people. I usually talk one-on-one. Dr. Betts has helped me a lot. He's been a huge help. I know he does care about George, and he knows he can speak for George's character. He's a good man, and I would never stand up here and ask someone to release someone that would be a threat to society. And there are many in prisons. They're not all good people, and they deserve to be where they are. They do. But there are some men and women that really don't, and they just need people to speak on their behalf and be their voice. And I just so happen to be George's voice. And I love him very much, and I believe that he has the proof to be released, to be a good man in the society, and to give back a lot. And just, remember, go change.org. I have many petitions. It's you can just type in George Trudell. Its last name is Trudel. Just type in George Trudell on change.org.com, and you'll see all the petitions. It's for HB 135. I could really use your signatures if you believe in it. SB 293 from Dalen Leach, the senator, and also a clemency petition for George himself personally. And that's taken off. We have 1,500 signatures so far, just since June. So thank you for your time, and I appreciate it.
Thanks, Liz. That was very poignant. I should add that, especially for the 1Ls in the room who are studying the felony murder doctrine, the SJC in Massachusetts just a few months ago ruled that the felony murder doctrine violates the state constitutional guarantee of due process, and that prosecutors had to prove one of the 3 prongs of malice to make it murder. So there's an example of action by the court to do what the legislature was unwilling to do in Massachusetts, which is repeal the felony murder rule. So questions, reactions? Yes, sir.
Good evening. Listening to you talk, I'm quickly reminded, and a lot of you are too young to know this, but there's an old Wendy's commercial where this lady hollers, "Where's the beef?" Now, as it pertains to the subject matter of the overall lecture series, I have to essentially ask the same thing, especially in regards to the church. You indicated that your values, presumably, I guess obviously I missed the first part of it, are aligned with the church. However, I don't see or didn't hear anything that brought the church into the discussion neither do I see anything relative to what the church is actually doing in regards to any kind of reform. You also mentioned that the U.S. Conference of Bishops has started in 1973 in regards to working on reform. They recently appointed an ad hoc committee, which obviously is 43 years in the making, and they obviously have not done anything of any significance other than the pomp and circumstance of the church that relates to any kind of reform in a number of areas, not necessarily just racism reform. So again, advertising for the fast food place, and I don't even eat beef, I have to ask, where is it?
Well, that's a fair question. I think that, I think that Pope Francis put his values right in front and center when he came to Philadelphia and visited a prison. He didn't need to visit a prison, and he didn't need to make the statement he made in prison about rehabilitation and redemption. I think if the U.S. Conference of Catholic Bishops was as strong a lobby in America as the National Rifle Association, you'd see more results on criminal justice reform. But they are not legislators. All that they can do is make recommendations, right?
You're passing the buck.
How am I passing the buck?
To compare the Conference of Bishops to the NRA, come on, that the NRA, as powerful as it is, actually that's a knock on the NRA, and by no means am I an advocate for the latter group. But to say that they are an advocacy arm as in line with the NRA.
No, that's not what I was saying, sir. I was comparing the lobbying ability and the power in Washington.
That is comparing.
No,
So-
that's not, but that's not saying that they're in line with each other.
No, I didn't say that. I'm saying that if you say that they have the potential of the NRA, does, as bad as they may be, and regardless of what anyone feels about the NRA, as bad as they may be, you have to give them their props in regards to the power of their legislative capabilities, their lobbying capabilities. And to say that the church, and just because Pope Francis was here and Mr. Gregory Porter wrote a song, Take Me to the Alley, just one's presence does not equate to any kind of reform. One's symbolicness of having lecture series doesn't bring about any kind of change.
Of course not.
You also mentioned that you were saddened that you engaged, and I'm not questioning you. If you've done something to be of more of a penitence type of mea culpa, that's all well and good. But if you say that the sentencing that you engaged in that were over the top as it relates to those of us who are permanently tan, that's all well and good, but you have to put the beef into your words.
Well, I think that's what I'm calling on people to do. I'm calling on people of faith, whether they be prosecutors or parole officials or governors or citizens who are voting, to put their faith into words in what they're being activists for.
Michael, can
Yeah.
I respond to that?
Sure.
The church is not just the bishops of the United States. It's all of us, I think, as you're saying, legislators and so on. But, for example, where's the beef at Villanova University? Since 1972, we have participated with Graterford in providing a degree program which has gone on steadily since 1972, and that's why George is an alum of Villanova University. Joe Betts has taught there, I've taught there, so many of us have taught there, and the university pays for us to teach there, except for me, because of my status, I'm a volunteer. But nevertheless, all those years, Villanova University has made it possible, originally for the inmates and the guards, to get a free education. The guards dropped out shortly after, but since 1972, without losing a beat, Villanova University has supported that program. Currently, we have 10 courses going on at Graterford, which we pay for, and is free to the inmates. In each class that I know I've taught, probably you've taught, about 25 men were in those classes. And we have, every year we have a graduation there, where we go out, and about 4 to 8 men graduate. Their families are there. So, in some way, that's part of the beef, that we as an institution, which is part of the church, the larger church, have given because of our belief system. So when you look at where's the beef and with regard to the church, and I'm not saying we've always been on the front line here, but you look around more broadly at all the aspects that are of the church. We are the church here. So what do? I volunteer to teach there because I believe in the program and I believe in redemption. So it's broader than just the USCCB as church. You're the church.
In Boston College has a similar program. Our undergraduate students go and tutor prisoners so that they can get their GEDs so that they'll be more eligible for employment when they get out. And that's part of our philosophy and theology curriculum. So I think there's more beef there than you're giving the church credit for. Other questions? Yeah.
Maybe. Thanks for your thoughts.
Yeah.
I was wondering what your thoughts were about particularly prosecutorial discretion being a part of like all maybe your recommendations, especially in light of the fact that our justice department might be kind of going backwards in allowing for that prosecutorial discretion
Right.
to be allowed.
Right.
So maybe someone of faith or
Right.
who maybe thinks there is room for reform, what is their place?
It's a very good question. I'm a huge opponent of Jeff Sessions' latest memo, which brings us back 20 years, saying that federal prosecutors have to charge the highest and most serious offense that the facts will prove. I think that that basically just allows prosecutors to use mandatory sentencing as a wedge to force guilty pleas, and it will end up that some people who are guilty get the benefit and some people who think they have a chance of innocence don't. So I think it gives too much power to prosecutors. I'm also a huge believer in that we really need to have lots of people of good faith and lots of people of diverse cultural and ethnic backgrounds going into prosecution so that they can see the effects of prosecutorial power on these decisions. The prosecutor is the most powerful player in the criminal justice system due to plea bargaining. So we really have to have a lot of people who are committed to justice and fairness go into this job and not eschew this job because they don't want to work for a racist system. That would be the worst possible effect in my view.
Thank you.
Yeah. Yes.
So I guess my question is, I mean, obviously we have to balance, protecting the innocent and all that. But so I guess something I've personally been ruminating about, I recently watched the Khalif Browder story documentary,
Yeah.
Or on Netflix, and it's occurring to me more and more that, prison isn't just, people are, away, or they're stuck in a building, right? It seems almost as that, like, violence is kind of, that's a feature, not a bug of prison, whether it's like body cavity searches, right? I mean, which, let's be honest, like, that's in a sense sexual assault, right? Or even just high rates of sexual assault and rape from other prisoners, but guards. Seems though, especially in the men's prisons, like you have to be violent just to survive. It's like, if you're not violent, you will be. So I guess it's just something I'm thinking about. Also, Pope Francis, something that is like way in the vanguard. People were like, whoa, Frank, like, calm down. Not just, we should get rid of the death penalty, we should get rid of like life sentences. I don't know, that's not a very coherent question, but just kind of, I don't know, like the ethics of prison would seem as though it's not just holding people at bay, it's intentionally like subjecting them to sometimes very horrible violence, right?
Yeah.
Not even to mention solitary, away from your family.
Yeah.
I don't know, I just didn't know if you had what ruminations you had on that.
Well, I mean, I think it goes back to what Brian Stevenson was saying about mercy, right? If mercy is an antidote to fear and hatred and evil, unnecessary body cavity searches are just perpetuating hatred of the system, hatred of law enforcement, and it's going to make somebody more likely to recidivate than less. So I think we absolutely need to look at the culture of our prisons, and I think that avoiding overclassification will be one way to do that, because the conditions you're describing are far more likely to occur in maximum security prisons or medium than minimums, where offenders are actually given more autonomy and they understand that if they do anything to jeopardize that autonomy, it'll be taken away from them in terms of free time, gym time, whatever, rec time, TV time. I think that's a far better model to encourage good behavior in prisons. But I think you're absolutely right. Well, thank you very much. It was a great discussion, and thank you to Villanova for inviting me.